Let's start with that ruling and just ask a very simple question, and that is, did you anticipate the court would rule the way it did, and what were your thoughts about the political impact that day of the ruling?
Well, I certainly did not anticipate that the court would rule the way it did, and I certainly, did not expect a unanimous ruling. I think probably a lot of Iowans were kind of surprised by that, and obviously saw major implications for the political scene in Iowa, which is still a very conservative state. A lot of Iowans probably weren't expecting to be blazing a trail on this particular issue. And I think it has proven to really have an impact going forward, and maybe for a very long time to come, on how the political scene goes in Iowa.
Do you think that, and this is a little bit off the topic, but Iowans are used to playing that caucus role, being the first in the nation. Do you think that changes how Iowans view their role, being one of the first states to judge this issue?
I don't know. I guess maybe David has an opinion about this. I would guess that there are people who are very engaged in this on both sides and want to be trendsetters or trend breakers, depending. Obviously the trend when it comes to ballot issues has been against those who want marriage equality. So there's an opportunity for Iowa to be on the cusp on either way.
What were your thoughts that day when this ruling occurred?
To some degree, I wasn't overly surprised at the ruling. I was surprised at the unanimity. Iowa has one of the most expansive grant of rights, I guess we'd call it, in its state constitution of any state, and it gave the Supreme Court a very useful hook. Right? There's also a very long and in effect proud history of the Supreme Court of Iowa in the area of civil rights, going well back into the 19th century. So to some degree there was that weight of history on top of a plain reading of the Iowa Constitution, which is of course the grounds on which the ruling was founded, right? And so in some sense it felt like that reading would almost have to happen. The 7-0 thing was a little bit unexpected, and I think clearly really, really important, because it sends a message. It harkens back, of course, to Brown versus Board of Education and the effort that the federal Supreme Court made to assure a unanimous opinion. At the federal level, when that happened back in 1954, one of the compromises in that ruling was the use of all deliberate speed in order to get 9-0. We know what that meant. It took a lot longer. Interestingly, in a sense, this ruling was much stronger than that, because not only did it base it on the plain reading of the Constitution, but it barred a legislative solution like civil unions. It essentially said that just isn't equality, and the Constitution requires equality. So in that sense, it was both one of those things where after the fact it seems almost obvious that it has to go that way, but it certainly didn't have to go that way 7-0.
Absolutely.